and others did not.
Tonight, we ask, should the Chief Justice empanel a bench to hear a case in which she is a party? This issue was subject of intense debate as Supreme Court judges. Attorney General battled former Law Society of Kenya President Nelson Havi. The judges of the Apex Court and Dorcas Oduor insisted that Justices Charles Kariuki, Bahati Mwamunye and Lawrence Mugambi are independent and competent to hear the cases they had filed. But Havi objected the issues, arguing that CJ cannot empanel the bench on the case. Imuraget brings us this story from the corridors of justice.
Should be handled together by the other matters.
The former Law Society of Kenya President Nelson Havi has argued that Justice Martha Koome ought to have delegated the duty to appoint judges or to hear a case to her Deputy Justice Philomena Mwilu. Havi now claims he fears he will lose the application and subsequently the case.
My lords, when you sit down, I want you to have no illusion. And this is my fear. I know this application will be dismissed.
Havi was seeking to have Justice Charles Kariuki, Bahati Mwamunye and Lawrence Mugambi withdraw from the case where the Supreme Court judges sued the Judicial Service Commission over petitions he filed seeking their removal from office. He also raised gender issues as the CJ had appointed an all-male bench.
My lords, FIDA have just been here. This bench is fully male. It's fully male. There's a problem. There's a problem. Where is the female gender in this bench? It doesn't meet the test set out in the Constitution and the Court of Appeal.
In her reply through her lawyers, the CJ argued that she had no vested interest while appointing the bench. Justice Koome's lawyer George Oraro said that the issue raised by Havi had already been settled separately by Justice Mwamunye and Mugambi.
My lords, FIDA have just been here. This bench is fully male. It's fully male. There's a problem. There's a problem. Where is the female gender in this bench? It doesn't meet the test set out in the Constitution and the Court of Appeal.
Oraro asserted that there is no window for the court to return the file to her, with an order that she hands the same to Mwilu for fresh appointment. He added that the CJ is expressing her right to approach the court for a violation of rights, just like in other Kenyan.
There is no application for review of the decisions which have been made before you, and there is no application questioning the right of the Chief Justice to empanel under Article 164.5, which ought to have been made if the issue was now to impeach the right of the Chief Justice to have empaneled this particular case.
Justice Njoki Ndungu backed the CJ submissions. Her lawyer Andrew Musangi argued that she is the only person allowed by the Constitution to appoint judges to hear cases in expanded benches. Justice Isaac Lenaola, William Ouko and Smokin Wanjala say that if the court weighs on Havi's argument that Justice Mwamunye and Mugambi should not sit as she was among those who interviewed them, it will mean that all judges ought not to hear any case against presidency, as the president appoints all judges. The Attorney General Dorcas Oduor, on the other hand, said she has confidence with the court senior state counsel Emmanuel Bita, who argued that Havi was seeking a review through the back door.
The party questions the exercise of a public power. They can only do it by way of a judicial review application.
Ruling will be delivered on November 13, 2025. Imuraget, KTN, Nairobi.
Now in politics.